Good morning. We are on the record in case number 9271 in the matter of the merger of Exelon Corporation and Constellation Energy Group. We'll begin today by taking appearances, beginning with Counsel for Monitoring Analytics, the independent market monitor for PJM.
Your Honor, this is Jeffrey Mays. I'm General Counsel for Monitoring Analytics, LLC, and we are here acting in our capacity as the independent market monitor for PJM. I also have with me Dr. Joseph Bowering, and he's available also for any questions you may have about the settlement and the other issues in this proceeding.
Thank you, Mr. Mays. We'll next turn to Counsel for Exelon, and based on the separation that was planned and announced today, if there's a number of counsel representing either Exelon Corporation, Exelon Generation, Constellation Energy, please help sort that out for me. We'll start with Mr. Curran.
Yes, good morning, Your Honor and Commissioners. Joseph Curran on behalf of Exelon Corporation, as well as on behalf of Exelon Generation, which is now Constellation Energy Generation. I'm also joined by my co-counsel today, who is also representing both companies, Matthew Price from Jenner & Block, who will be assisting. We also have two representatives of the companies here, Your Honor, this morning, Ms. Melissa Lavinson, who is a Senior Vice President for Exelon Corporation in their Federal Government and Regulatory Affairs Department, as well as Ms. Carrie Allen, who is a Senior VP and Deputy General Counsel at Constellation, as of today, Constellation Power Energy Generation.
Thank you. Mr. Curran, can you give us a status? Has the separation occurred already today or will later on today?
I see that Ms. Allen's head is nodding that it happened this morning, Your Honor.
Okay, thank you. So there's no conflict for you representing two unaffiliated companies?
That's a great question, Your Honor. They're proceeding today under a joint defense and common interest agreement, so there's no conflict for either Mr. Price or myself to represent both companies today.
Okay, so there's an agreement in place. And one last question. Mr. Price is an out-of-state attorney. Has he waived in?
He has, Your Honor. We filed the necessary paperwork and we filed that with the commission last week.
Okay, thank you. We'll next turn to Maryland Office of People's Counsel.
Morning, Your Honor. Commissioners, William Fields for the Office of People's Counsel. I have with me today Douglas Smith with the firm of Daymark Associates. We pre-filed testimony for Mr. Smith on October the 6th, I believe it was.
Thank you, Mr. Fields. We've received Mr. Smith's testimony and have reviewed it. We'll next turn to Public Service Commission Staff Counsel.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. I'd also like to enter the appearance of Lloyd Spivak.
Thank you, Mr. Dean. All right, this case goes back to March of last year when the Monitoring Analytics filed their report as required under the terms of the 2012 merger order, which approved the merger agreement between Exelon and Constellation. We've since received a wealth of pleadings over the course of the past several months from these four parties. On December 30th, Exelon Generation and Monitoring Analytics executed a partial settlement agreement that continued the terms of these behavioral conditions through the 2031 to 2032 delivery years, so approximately 10 years, along with associated changes to Exelon's fuel cost policy. In reviewing the pleadings, it does not appear that any parties are opposed to approval of the settlement today, although I do recognize Office of People's Counsel wishes to have the commission not provide any finality with respect to an extension in 10 years although I see that both the signatories to the settlement agreement have agreed not to proactively seek an extension after the terms of the 10 years. Do the parties agree with that recitation?
Your Honor, William Fields for the Office of People's Counsel. We do not have any objections to the terms of the settlement agreement itself. However, there are two issues that remain for the commission to decide. One is whether the commission should continue the requirement that Exelon stay in PJM until further order of the commission. And the second is, should the commission set a definitive end for the measures to counteract the ability of Exelon or its successor to exert market power and harm Maryland consumers. OPC believes the commission should answer both of those questions in the affirmative. We've presented our arguments in favor of that on August the 6th and January 27th, part of the number of pleadings that you've heard. As I stated before, we've pre-filed the testimony of Douglas Smith. He addresses both of these questions. We request that his testimony be accepted and considered. We pre-filed that on actually October 4th. I was mistaken when I said the 6th. And so we believe that the commission needs to have an evidentiary record to answer these questions. We noted that on January 21st and 27th. Mr. Smith is available here to take the stand and answer questions on that pre-filed testimony. I will proffer for the commission that his opinion is that the behavioral restrictions in the settlement agreement are reasonable protections for Maryland customers. And like I said, he can answer further questions on that. However, all that being said, we still have the two questions that the commission needs to answer. I won't repeat the arguments that we've been made in writing on those two questions, but would happy to answer questions about it.
Okay, thank you, Mr. Fields. But just to be clear, the simple question is the Office of People's Counsel does not oppose the partial settlement agreement before the commission.
No, Your Honor, as far as it goes, we have no objection to it.
Okay. So what I'd like to do is handle the partial settlement agreement first, and then we'll turn to the severed issue with respect to whether or not Exelon Corporation should be required to remain in the RTO in perpetuity. At this time, I'll turn to my commissioners if they have any questions or concerns with respect to the settlement agreement before us today. Seeing none. I would move that the commission approve the revised settlement terms and conditions as filed on December 30th, 2021, case jacket number 704. The settlement agreement consists of 3 pages with a 4th signature page signed by Carrie Hill Allen, Vice President and Deputy General Counsel for Exelon Generating Company, and also signed by Jeffrey Mays, General Counsel for Monitoring Analytics. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton. Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The partial settlement agreement is approved. We'll now turn to the major issue that we've seen a lot of argument and legal pleadings, and that is with respect to requiring Exelon Corporation to remain in PJM. Commission has reviewed the feels like dozens of pleadings that have been filed. Most recently, we've had a round on January 27th. Of the 4 parties, 2 of them, Exelon and commission staff, believe that the commission has no authority to require Exelon Corporation to stay in the RTO. The Market Monitor and Office of People's Counsel says that the commission can require Exelon to stay. Obviously, we have a merger order from February 17th of 2012 that remains in effect per the terms of the IMM settlement, I believe, for another few weeks. And we'll also recognize that sort of the FERC and the Federal Power Act have a role here. Of course, RTO membership is voluntary per terms of order number 2000 at FERC. So let me begin with asking this threshold question. And of course, if the commission does not have authority to require Exelon to stay, then everything else is mute. There are no material issues of facts, and no need for an evidentiary hearing based on that. So, Mr. Mays, I'll start with you. Does the Maryland Public Service Commission have the authority to decide for all 13 states and the District of Columbia whether a wires-only company such as Exelon Corp is effective immediately to remain in the RTO?
Your Honor, I would phrase the question a little differently, and that is that what we are looking at here is the merger that was approved in 2012. It was approved for, and it was approved subject to conditions. Those conditions included behavioral commitments, and those behavioral commitments included an implied commitment to stay in PJM. In condition number 8, the commission made that condition explicit. And then in condition 9, it created this process to review in 10 years whether to extend those behavioral commitments, which is what we're doing today. We just approved the settlement that extends the commitments that relate to participation in the markets. The only remaining question is, as in 2012, is there an implied commitment to stay in PJM? The applicable precedent is the 2012 order. In that order, it found that in order to fulfill the conditions of the terms of the settlement, it was necessary for Exelon to remain in PJM. And then it further determined to make that condition explicit, and Exelon accepted it. And so now in 2022, we're in substantially the same situation. We've agreed to a settlement for the same reason as in 2012. Exelon cannot fulfill the terms of that settlement without remaining in PJM. It is therefore an implied commitment of the settlement. And therefore, it should also be made explicit for the same reasons it was in 2012. So this is not about a separate exercise of the commission's authority. This is about terms that Exelon agreed to. Exelon agreed to the process that we are in here today. And the commission can determine whether to extend the conditions, including conditions 8 and 9 that are at issue here. And so it's not about imposing a regulatory condition on Exelon. It's about extending, pursuant to the process that Exelon has already agreed to, the terms of the settlement and the explicit, making explicit an implicit term of that settlement that Exelon remain in PJM.
So, Mr. Mays, you're referring to the 2011 IMM settlement, and Exelon at that time voluntarily committed itself to remain in PJM for a period of 10 years. That implicit condition, as you noted, was made explicit in the commission's merger approval order. However, over the course of the past 10 years, notably this morning, the world has changed. That merger order focused exclusively on generation market power. As of today, Exelon Corporation owns no generation. Is your argument that because Exelon Corporation signed the 2011-2012 merger agreement, they are in perpetuity required to stay in PJM?
Our argument is that when they accepted the conditions that the Maryland Commission imposed on the merger, exercising its conditional authority, that Exelon was thereafter bound to adhere to those conditions. And those conditions included the behavioral commitments, which included both the settlement terms and the term that was made explicit, but that was found to be an explicit part of the settlement. And it also included the process that we're in here today. And this process has the potential to extend the terms beyond that 10 years. And that was also agreed to. It wasn't Exelon's agreement to the settlement. It was Exelon's agreement to accept the commission's merger conditions.
And Exelon did accept those terms, but not in perpetuity. There was a term associated with the IMM settlement that brings us to February of 2022. Mr. Curran, following up on something Mr. Mays just said, he stated that Exelon Generation, or for the purposes of this hearing, will now use the actual legal name, Constellation. Constellation would not be able to honor the terms of the behavioral commitments the commission just approved 2 minutes ago if Exelon Corporation departs PJM. How do you respond to that?
Your Honor, I'm going to defer to my colleague Matthew Price on the question of enforceability, but our position is this isn't an enforceable agreement once the commission approves it, and Mr. Price will discuss, other aspects of the enforceability issue.
Thank you. Mr. Price, do you understand the question? It was one that was raised multiple times in the pleadings by both Monitoring Analytics and the OPC.
Yes, sir. So I think the first point I'd make in response is that I think it's important to step back and understand why the conditions were applied in the first place. And it's as you said, Your Honor, there are large amounts of generation that were combined with large amounts of transmission in the 2012 merger. And things have fundamentally changed given the separation of the two entities. And Exelon Corp has no ability to exercise market power. It's just a wires company. It has no horizontal market power and no vertical market power. And Exelon Corp is not entering the partial settlement agreement. That agreement is between Constellation, which is today a separate company, and the IMM. And that agreement can't impose an implied obligation on a third party that has no market power, Exelon Corporation, just to aid in the enforceability of the agreement. So that's the first answer. The second answer is that, to the extent there's concern about, well, what would happen if Exelon Corporation would leave PJM? If that were to happen, there would be a FERC filing. And this commission and the IMM would have ample opportunity to tell FERC about the settlement agreement, advocate for parallel behavioral conditions to be imposed on Constellation, whether it's inside or outside an RTO. I'd note that the settlement agreement itself applies to Constellation as long as it's selling into PJM, even if the utilities are no longer in PJM, that is if their external resources selling in PJM. And of course, Constellation, in response to any kind of filing by the commission and the IMM, would be able to explain why the conditions are unnecessary, and FERC would then decide. And FERC also has remedies beyond just saying, no, you can't exit. It can consider what's in the public interest and whether any conditions are needed to effectuate the public interest. So FERC would make that decision. And I think it's notable also that, the IMM in the PEPCO merger made the argument to FERC that it should impose a stay in PJM condition on Exelon in connection with that merger. And FERC said, no, we're not going to require that because it's inconsistent with our policy of voluntary membership in RTOs. And the FERC said that it has adequate tools and authority to address market power concerns if Exelon were to leave PJM at that time. And I think that's the same answer that should guide this commission. There are tools to address that situation if it ever were to arise. But right now it's purely speculative.
Thank you. I'll return to Mr. Mays. I'm still struggling with the argument that this Public Service Commission has the ability to bind Exelon Corporation to remain in PJM for any particular period of time beyond its voluntary commitment, the quid pro quo, if you will, for merger approval here. Where in our statute do we have that authority? If you could provide a cite, or are you saying that there is no statute, but the terms of the merger agreement in 2012 is all that we have to keep the tether on Exelon?
Right. The part of the statute that I'm referring to is the commission's merger authority and its conditions, its ability to condition mergers. That's section 6105 of the Public Utilities Article. And that is the only section that I'm referring to. That provision includes the ability of the commission to set conditions on mergers. That ability is very broad. The commission set conditions on this merger, the merger of Exelon and Constellation. And Exelon Corporation is the party that emerged from that merger, and it is the one that has these commitments. Exelon voluntarily agreed to all of the merger terms and conditions. That includes the behavioral remedies in 8, and it includes the process that were in condition 9. And so, to whatever extent membership is voluntary, Exelon has made a commitment, actually twice now, and also in the additional proceeding that you indicated, where it has agreed to stay in PJM. And it could have not accepted the merger conditions and the benefits, but it did accept the merger conditions and benefits. And so now it's bound by them. It's bound by the process. It's bound by this process.
Mr. Mays, your argument is that they're bound in perpetuity. I just want to get that on the record. Is that right?
No, it depends on what the commission decides in this proceeding.
Okay, so it is up to the commission's discretion. And how would you respond to the fact that this hearing, which was just coincidentally scheduled on the same day as the separation, and the fact that an effective divorce now between generation assets and transmission assets have occurred, how does having Exelon Corp be bound to what I see here on page 104 of the merger order, which is condition number 8 and condition number 9 on page 105? What effect, if any, does condition 8 and 9 have on a wires only company that warrants us to keep them in the RTO?
Right. The commission in 2012 explained its reasons. Its reasons were to enable Exelon to keep its commitments that related to market participation. That remains equally true regardless of whether they remain one company or whether they're split. Exelon Corporation is the one who controls the transmission assets, including transmission assets it acquired in Maryland as a result of the merger. And so therefore it remains the party that determines whether or not the company remains in PJM and whether it can continue to fill its commitment. And those commitments don't expire as a result of the spinoff. Both parts inherit those obligations because they voluntarily agreed to the merger terms and they have benefited from those merger terms, which have been in place for 10 years. And now the issue is whether to protect Maryland ratepayers for the same reasons it chose to protect Maryland ratepayers in 2012. Those terms should be extended.
Mr. Mays, I would agree with you. I would agree with you that the terms don't expire with the consummation of this divestiture, which none of us could have predicted. But the IMM settlement was for a period of years, expiring this month. I'm still struggling to square this argument that PJM should continue to have Exelon Corporation as a mandatory member for a unknown period of time. Let me turn to Mr. Fields to see if you have any legal argument. This is really a threshold question for me. I don't need to get to the rest of my questions if this commission has no authority to require Exelon to stay.
Thank you, Your Honor. The commission certainly has authority at this point, and that authority is derived directly from the merger order. As Mr. Mays was saying, I mean, the order itself makes the condition valid until the commission determines otherwise. The fact that parties to the case decided on agreed to a 10-year term is really irrelevant to the commission's determination of whether it's in the public interest to end this condition.
Mr. Fields, where does it say that in the merger order that we have?
It says the commission may extend the terms of the IMM settlement if, after an evidentiary hearing addressing market conditions, the commission determines that the expiration of the behavioral remedies in the IMM settlement will, through the applicant's increased ability to exercise market power, pose a significant risk of harm to Maryland ratepayers.
And Mr. Fields,
go ahead.
We just did that 10 minutes ago. We approved additional behavioral commitments to continue for another 10-year period with respect to the utility company, Constellation. I'm still having trouble with respect to why your client sees the need to keep a wires only company bound by the terms of this merger agreement, which the underlying IMM settlement is coming up for expiration.
Yes, thank you, Your Honor. The reason the commission should exercise its authority to retain this condition, to continue the condition, is that if Exelon Wires Company chooses to leave PJM next year, for whatever reasons it has, and those reasons could have nothing to do with generation, has its own reasons for that. However, if it chose to do that, the generation within the PJM footprint would no longer be in the PJM footprint, and that would include generation within the BGE, what's now called the BGE load deliverability area. But if Exelon left, that wouldn't be part of PJM, so it would no longer be that. But the transmission conditions would still be in place, that is a congested zone where the generation within that zone has the ability to exert market power, as the market monitor has explained in previous filings before you. And that situation would continue with a concentrated market, which resulted from the merger 10 years ago. Now, if market conditions changed beyond, moving forward from today, there certainly could be a petition to say Constellation Generation sold some generation, things have changed. There is no longer this market power concern, particularly with respect to local areas. The commission can make a determination in the future that these conditions are no longer necessary. But the record before the commission today is clear that after the spinoff, there's still a firm that controls significant amount of generation to make it pivotal to, and that's why these requirements are necessary. Again, as the IMM has explained.
Mr. Fields, that generation is Constellation's generation. And you mentioned a moment ago that some of the generation may be departing PJM. Mr. Curran or Mr. Price, are we talking about any generation leaving the RTO?
But Your Honor,
I'm sorry, Your Honor. Can you repeat that? I mean,
maybe I'll have Mr. Fields repeat it. Mr. Fields,
my point is that, I'm sorry, if I can keep going.
Well, Mr. Fields, you've linked a lot together, and my question is, where does the authority exist for the commission with an expiring settlement to require Exelon Corp to stay in? I don't really care about the market power issues after, if we can't have the legal authority to retain Exelon Corporation, and I'm not even sure there are any market power issues with a wires-only company. That concept sort of confuses me, and maybe we'll get there if we're satisfied that we have the legal authority.
Well, Your Honor,
we'll let Mr. Fields finish, and then Mr. Mays, you could address that.
Okay. Yeah. Well, I was going to point to some of the IMM filings that were made back in March, and so I won't go on about that.
Let's not go there, because if we don't meet the threshold question, we don't need to get into the argument of transmission market power, for lack of a better term.
The threshold question, Your Honor, goes back to the merger order, which made this condition indefinite until the commission, in its discretion, as you stated earlier, makes a determination that it's acceptable to the commission to allow these behavioral restrictions to expire.
Okay,
and
all right.
The fact that the behavioral restrictions go to a successor now instead of the company that's now called Exelon Corp is irrelevant.
Okay.
What's relevant here is the public interest to prevent market power harm to market power from harming Maryland customers.
So let me rephrase. You just stated that there is no obligation for Exelon Corporation to stay in the RTO, and it's up to this commission today to make that determination. The commission has that discretion. It is not bound by any prior agreement.
Well, Your Honor, if you mean that Exelon Corp is not bound by any prior agreement, I suppose I would agree with that. It's up to the commission. You know, the commission's authority is not determined by what Exelon or IMM agreed to 10 years ago or now. The commission has its authority. It exercised that 10 years ago to say that Exelon, if you want to merge, you're going to have to accept that the Maryland Commission has an indefinite ability to require that Exelon stay with those areas, that those service territories stay within PJM. Commission has the discretion to change its mind, to determine that that's no longer necessary, but it retained that authority 10 years ago, and it still has it today.
I would argue that it seems like it had no authority. I would argue we had a voluntary commitment from Exelon Corporation to remain in the RTO for a period of 10 years, and we'd revisit it at this time. Mr. Mays, I'll turn to you.
I don't agree that the agreement was to stay in PJM for 10 years. The settlement agreement was that, but that's not the complete merger conditions.
Mr. Mays, you referenced two agreements. What was the first agreement?
First agreement was a settlement agreement that was approved in the 2012 order.
Okay, and what's the second?
And so the second agreement is the one that was just approved by the commission just now.
Okay, I might have lost you. If you could begin your argument again.
Right. So what happened in 2012 was a settlement agreement was filed, but the commission modified that agreement. One wasn't really a modification. It was an interpretation that there was an implied commitment to remain in PJM in that settlement agreement.
Correct. Correct. Mr. Mays, so it was an implicit condition that Exelon Corp stay in for 10 years that the commission in 2012 made. It was an implicit condition that the commission made explicit, and Exelon Corporation did not seek rehearing within the 10-day window. So effectively, they conceded that they're going to stay in PJM for 10 years.
Well, they also subsequently submitted their notice of consummation, which meant they merged and therefore accepted the agreements by which the commission approved that merger. So it wasn't just the failure to take action, though they could have argued the point. They accepted the conditions. They accepted the settlement, but they also accepted the explicit condition that Exelon remain in PJM, and they did not argue against the commission's reasoning. That if they had filed for a hearing, what they would have needed to address was the precedent set in that order that if a company agrees to behavioral conditions in the market, it's also agreeing to stay a part of that market as an implied condition and also an explicit condition. And so the commission found that Exelon needed to remain in PJM in order to fulfill its other commitments. So it wasn't about the market power of transmission or whether it was wires only, it was about meeting those commitments. And condition 9 applies to all of Exelon, even if it splits up. So now we have a newly approved settlement agreement where Exelon has committed to market behavioral conditions, but they can't do that if Exelon leaves PJM. So the part of Exelon that controls that determination, that part also needs to stay in PJM as well. And the merger was approved for all parts of Exelon Corporation, and that continues even if there's a split up.
All right, thank you, Mr. Mays. I'm going to turn to my colleagues for additional questioning on this legal issue. Commissioner Herman.
Thank you, Mr. Chairman. Mr. Mays, one of your filings, and I have so many I can't find which one, said that the limits on Exelon's behavior apply to Exelon based on Exelon's voluntary commitment. You agree with that, right?
Yes, I think it was voluntary. They agreed to the conditions. They could have, they didn't have to agree to the merger
Yeah,
conditions.
yeah, I get it, right? So, now, now I want to talk about the new settlement, the one that was just filed, that was just approved. Is Exelon a party to that settlement?
Yes, we believe Exelon is a party to that settlement. We could not have reached that settlement without the agreement of the whole company.
The thing is, it says this is between Exelon Generation LLC, which is now Constellation. You agree with that, right?
Yes, but at the time we agreed to the settlement, it was part of Exelon Corporation.
But hadn't they already announced that they were leaving, that the generation was being divested when you signed the settlement?
Yes, Your Honor, they had announced that, but they had not yet, that had not taken effect. That didn't take effect until today.
But you were clearly aware that that was going to happen. Is that not the case?
Yes, we knew it was going to happen.
Okay. So I guess the implicit, you're saying that this new settlement has no value unless Exelon stays in PJM, the same way it didn't have value without the implicit agreement back in 2012, right?
Yes, we agree with the commission's determination in 2012.
Okay, but
And we also, I'm sorry, Your Honor.
but the settlement in 2012 was that it was the expiration, and you could extend it if the applicants were able to exercise market power in the markets controlled by the IMM settlement of 2012, which was all about generation market power. Would you not agree?
Yes, Your Honor, I agree that the settlement terms were about market participation by generation.
Right. So I'm having a really hard time trying to understand why Exelon, current Exelon, which is now a wires company, if we're talking about market power with respect to generation, then why is it important to keep Exelon, the wires company, in PJM?
Is because membership in PJM primarily is a matter of transmission ownership. So what happens when a company joins PJM? The most important thing they do is they transfer operational control of their transmission assets to PJM. And they also become part of the PJM region, and they become part of the PJM markets and all the market rules that relate to PJM. And all of that depends on the transmission owner remaining a part of PJM and keeping its assets in PJM. If a transmission owner removes its assets, then it's removing everyone else who is participating in that market from PJM as well. So if you're a generator interconnected to that transmission system and Exelon decides to leave PJM, that generator doesn't really have a choice. It's going to have to follow the transmission system where it has its interconnection agreement. So it's effectively removed from PJM. And so it's removed from the scope of the rules, from the market. It becomes like any other external generator to PJM. So as the commission found in 2012, you can't meet the commitments that are established under the new settlement or the old settlement without Exelon remaining in PJM. And
So are you saying that if Exelon chose to leave PJM, any generator within all of the Exelon footprint, including Pico and everybody else, would no longer be able to participate in the PJM market?
what it does is it changes it from being an internal resource that is directly subject to the market rules and the market design to becoming an external resource. And so, MISO has generators that sell into the PJM market, but their status is entirely different. And their relationship to the market monitor and to the rules we've established under the settlement is entirely different. We can't enforce the settlement on generators that aren't participating in the PJM market in the direct sense of being members of being internal resources.
So now let me ask you another question, which is, isn't that a FERC issue, not a Maryland Public Service Commission issue? Because then I'm starting to get into all of PJM, and it impacts PECO, and it impacts all these other companies. How do we have jurisdiction if Exelon, if you, as you said, Exelon's participation in 2012 was voluntary, and now they are no longer voluntarily doing it? How is it that we have jurisdiction?
Well, I guess one is that voluntary doesn't mean that the company can't commit to take actions. It means that, the Federal Energy Regulatory Commission doesn't run a mandate for participation, but it doesn't mean that the company can't agree to participate.
So, but I'm sorry, I'm just confused, because voluntary means we don't have jurisdiction. We didn't have it before. Exelon voluntarily agreed to do it. And then that's, that was part of the merger condition, and they voluntarily did it. They
Right,
could have said no, and they could have said, we won't merge. Fine,
That's
but
fair.
that didn't happen. But we don't have that same voluntary agreement here, do we?
I think that you have a voluntary agreement. You have what is, I think, akin to a contract, where the commission said, we have reservations about your merger. We're imposing these conditions. If you want to merge, you have to agree to these conditions. Exelon agreed to those conditions and got the benefits of a merger. And so it exercised its voluntary decision to make that commitment. It also committed to a process that would evaluate whether or not those conditions needed to be extended. And it has now agreed that those conditions needed to be extended as far as participation is concerned. And so now the transmission assets, that's an implied commitment to that agreement. And so they need to stay in PJM. Otherwise, that agreement can't be fulfilled. All of that is voluntary. It's all about the merger conditioning authority of the commission, and the fact that Exelon agreed to those conditions, including a condition 9, which is what this process is all about, a determination about whether, in order to protect Maryland ratepayers, those conditions should be extended, and they should.
Okay, thank you.
We'll turn to Commissioner Linton.
Thank you, Mr. Chairman. Good morning, everyone. I had a couple of questions for OPC and for the IMM. In your filings, as others have stated, there have been several, but you've noted a couple of times, and correct me if I'm wrong here, that the settlement terms and conditions, the revised settlement terms and conditions that were just approved, that there are provisions in them that are not effective if Exelon does not remain in PJM. Am I correct in that assessment?
Yeah, that's you're on William Fields for the Office of People's Counsel. That's right. Just to take an example, if BGE were to leave PJM.
Well, actually, Mr. Fields, I actually have the settlement in front of me. So point me to a section where I can then ask Exelon if what they think of your position here, because I want to make sure that what we just approved doesn't have some loopholes or gaps in it, or something that we need to be concerned about. So you're suggesting that the provisions here are not enforceable. So help me to understand what you're
Right. All right. If Exelon left PJM, those areas, those service territories would no longer be part of PJM. They'd no longer be, the PJM rules would no longer apply to serving load in BGE. And the generation within the service territories that left, now they could sell into a PJM area. They could sell to, PJM would still be, First Energy would still be part of PJM. Those generation units could sell into First Energy. So if you look at the provision B4, for example,
Okay.
no unit or part of a unit will be offered as max emergency except as necessary to comply with environmental limits or fuel limits. Now, I suppose that for a unit physically located within a service territory that had left, if that was selling into what was remaining of PJM, you could say that, well, they still have an obligation to sell as not to offer as max emergency. However, that doesn't help Maryland consumers because the equivalent, because selling to serve Maryland would be done under a completely different regime. It's no longer PJM. Whatever is set up to replace that is what they would be selling under to serve Maryland customers. So this provision, for example, would have no force, wouldn't mean anything for a Constellation unit selling to serve Maryland load in a territory where Exelon had left. So there's other, there's a number of provisions in here that are the same way. In serving Maryland load, that provision would have no meaning.
So thank you, Mr. Fields. Mr. Curran, or any of the other council, what's your response to that?
I'm going to defer again to Mr. Price on the question of enforceability, Your Honor. But again, we will repeat that Mr. Fields' question is a hypothetical. This is an enforceable agreement now that it's been approved. And as for what would happen in the future in terms of enforceability, I'll defer to Mr. Price.
Thank you. So, yeah, I mean, I think the place to start is to recognize that the agreement is enforceable today. And, it's speculative whether there would ever be a situation in which Exelon Corporation would leave PJM. The terms of the agreement define the behavioral conditions as being applied to generating units owned or controlled by XGen, now Constellation, in which are either located in PJM or sell into PJM. So that's the scope of the terms and conditions that were agreed to, which makes sense because the IMM is the IMM for PJM. But
I'm sorry, just for a second, I'm sorry, where is that language?
That's
Is it-
under one. It's
Okay.
a behavioral commitments under section 1.
Okay, gotcha.
But I think what we're talking here today is about whether there needs to be an additional condition imposed involuntarily on Exelon Corporation, which owns no generation, which can't exercise market power at all, either horizontal or vertical market power, and is no longer an affiliate of Constellation. And so that's the question that the commission is faced with now. And with respect to that issue, we think that there's no basis at all for the commission to impose that obligation on a party that can't exercise market power just to aid in the enforceability of a settlement agreement of a separate entity. And I would also add that, as I stated before, that if Exelon Corporation did leave PJM, there would need to be a FERC filing made under the PJM tariff, and everyone, including the commission, would be able to have opportunity to tell FERC about the issues of market power that they perceive and the conditions that they believe should be imposed. And there could be that proceeding before FERC, and FERC would decide what was appropriate in the wholesale markets that it has jurisdiction to regulate. And FERC has made clear, again, in the Pepco Exelon merger, where this exact question was placed before FERC, FERC has made clear that in that event, it has the tools that it needs in order to protect customers.
Your Honor, if I might respond to that, none of that explains how it would work if Exelon left PJM. This provision that I pointed to, no unit will be offered as max emergency. That's offering a unit as max emergency is a way to withhold the unit from the market and drive up price. That protects Maryland customers if we're talking about a peaking unit, in Maryland that could be withheld to drive up the price for other generation in Maryland. If Exelon had left PJM, that restriction would no longer prevent a Constellation from withholding the unit from service to Maryland, and therefore that could harm Maryland customers. We don't know what terms and regime would be in place if they left, if Exelon left PJM. We know that there's a set of rules and there's a requirement here not to offer as max emergency, and we know that that provides a level of protection to Maryland customers. If Exelon left, we don't know what would happen with that.
Your Honor, if I may, this is Carrie Allen. So I think two things would happen. If Constellation continues to sell into PJM, these commitments apply. If, let's say, Constellation units were located in MISO, then the MISO rules that apply to max emergency would apply. And those there would be a chance to discuss whether those rules are adequate at the FERC.
Your Honor, the answer to the question, and I think Mr. Price said a lot of other things, but as he explained, the agreements with the market monitor for PJM and our authority to review offers and to protect Maryland customers from the exercise of market power is primarily within the PJM market design. And that is why it's so important that they not exit the PJM market design, because we can't fulfill terms of this settlement unless that happens. And that's what the Maryland Commission found in 2012, and that remains true. And just a short note about why that's important to Maryland ratepayers. PJM has a very effective market power regime. It's not perfect, and we are continually trying to make it better. We've had some recent success in that area, but it is a very effective market power prevention regime. It allows us to review offers ex ante and attempt to raise issues before they end up embedded in prices. And that is not like other markets, and it's certainly not like a non-market regime. And for Maryland customers to continue to enjoy those benefits and to enjoy the protection that the market monitor is able to provide under the PJM market rules and under the very important rules included in the settlement that was just approved, that means that PJM membership is necessary. And so in the settlement itself, it raises the fact that we were going to bring this issue to the Commission's attention. And so that was known when the settlement was signed. It's in the settlement that it's an open issue, and that is why we're bringing it here now. So thank you.
All right, thank you, Mr. Chairman. That's all I have. Thank you to all the parties.
Thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. Let me start with Mr. Fields. Mr. Fields, would you agree that in 2012, the condition that required retention in PJM was based on generation market power?
That was certainly the the issue that was discussed most in the in that case. There was also testimony on concerns about undue influence by the size of the company within the PJM process, but I wouldn't dispute that there was more discussion about the generation horizontal market power issues.
So that being said, would you agree that this commission could sua sponte create a proceeding that required the wires only companies in this state, Potomac Electric, Pepco, BG&E, Delmarva, even Smeco? We have clear authority, if we wanted to tell those transmission owners they need to stay in PJM. Wouldn't you agree we have the ultimate authority to get there should we decide to?
Your Honor, that staff has made that argument. I would tend to agree with it, although I can't say that we've fully researched that issue.
Just for argument's purposes, just we'd have to go through a proceeding, we'd have to have hearings, we'd have to have evidentiary hearings, we'd have to leave all parties and stakeholders agree, but But is it possible, arguendo, to get there via this commission?
Your Honor, as I sit here, I don't want to say that it's not.
All right,
But
that's good
I
enough.
I can't honestly say that we fully researched it and take a position that you have that authority independent. I don't think it's necessary to get there in this case.
I don't think it is either. I don't either, and that's not why I'm asking the question, because I'm asking the question to set up this question. What authority do we have to order a wires-only company in Illinois, Commonwealth Edison, or in Pennsylvania, Philadelphia Electric, to remain in PJM? They're wires-only companies. We have no jurisdiction over them. What authority do we have to effectively require them to remain in PJM?
I don't think you do unless,
That's, if we do what you say, that's what we're gonna do.
well, if I could finish the thought, you don't unless a company comes to you and says, commission under Maryland law, we want to accomplish a merger that requires commission approval. And
But
we
they
are,
they weren't wires-only companies back then when we did that.
that's right. They weren't. But the transaction under Maryland law needed the commission's approval, and the commission had an evidentiary hearing and said, the commission had the right to say no to that.
Yeah, but
To
I
the
don't think we
merger.
have,
And the
I don't think we
commission
have that right as of this morning going
has-
forward.
Well, it
I'm
goes
having a hard
back
time
to the
with that.
same, the commission had the right 10 years ago to deny the merger. It also had the right to say, this merger is only in the public interest if we impose a condition. And that's what the commission
All right,
did. And
thank you.
that condition said, until we, the Maryland Public Service Commission, say otherwise, we can continue to impose these behavioral restrictions, including the requirement to stay in PJM.
Thank you.
Exelon voluntarily, and this is the point where their voluntariness is important. They agreed to those conditions when they closed the merger.
Thank you, Mr. Fields. Mr. Mays, let me turn to you. I got a question
Your
for you.
Honor, I certainly would not disagree that you have other authority whereby you could attempt to address this issue.
Hang
But
on.
not-
Hang on. I'm gonna ask you a different question. Okay?
Okay.
Thank you. So my question to you is the 800, the big player in all of this is not even present here, and that's PJM. Where are they? They're not here. They're not represented. They're not being heard. What does PJM think of all of this? Do they have an opinion at all?
Your Honor, as you know, we are independent of PJM and I cannot speak for PJM.
I just find it amazing that I'm going to make a decision that has a potentially dramatic impact on the largest market in the world, power market in the world, and they're not even here. And I'm going to decide for the entire footprint of PJM based on this, and nobody even knows what they think. That's all I have, Mr. Chairman.
Thank you. Any additional questions from commissioners? Mr. Curran, maybe another elephant in the room. Does your client expect to depart the RTO anytime soon? I recognize you're under commitments with some other mergers, including Pepco, I believe, to stay within PJM for a couple more years.
Your Honor, I'll defer to Ms. Lavinson, who's on the line here about that question, but again, that's not on the agenda, but I'll let Ms. Lavinson answer you directly.
It's Your Honor, Exelon, we have no current plans to leave PJM.
Thank you. All right, at this time, the commission will adjourn. We will take these arguments under advisement and issue a ruling at some point in the future. I recognize that we do have a date that we're trying to get to. I believe our last action date is March 12th, which is 10 years after the consummation of the actual merger, not the commission's merger order. Do the parties agree that that's the last date of action for the commission, March 12th?
That's correct, Your Honor. Although we don't think you need to even decide this issue, but the settlement agreement is in place as of, it's effective and will be effective after March 12th.
Thank you. I don't hear anybody
Your
disagree.
Honor, we have asked for a decision by March 12th, but we don't see anywhere in the condition 9 or 8 where once you've initiated the process, it says the date by which you must make the finding. So I think that's an open question.
Okay. Thank you. I do recognize we didn't get to additional questions today with respect to actual market power. We've asked a lot of questions on the threshold question. If the commission determines that material issues of fact exist, we can proceed to an evidentiary hearing as Mr. Fields requests. I know that Mr. Dean has withdrawn his request for an evidentiary hearing. However, if we don't get past the threshold question, then we have no need to schedule something between now and March 12th. Before I adjourn, do the parties have any final matters to address?
No, thank you, Your Honor.
Your Honor.
Your Honor, I would just address the last point, and that is I don't see why you have a robust record before you. I think we have had a hearing. I think that it would be reasonable to deem this an evidentiary hearing and deem it to have satisfied obligations under the process. That said, we're certainly willing to participate in any future hearing or investigation process that the commission chooses to establish.
Thank you, Mr. Mays. I do believe we have a wealth of a sort of paper hearing that has developed over the past 6 months. We will review the arguments, particularly the legal arguments that the parties have made with respect to this severed issue, and we will endeavor to get a written decision out on or before March the 12th. So, thank you.
A question on what Mr. Mays just said.
Yes.
Is he saying that we do have enough information right now to make a determination on market power and with regards to potential harms to Maryland ratepayers?
I believe that's what he
Is
said,
it-
but Mr. Mays, did you hear Commissioner Richards' question?
Yes, that's what I said.
Okay.
I think it only pertains to the requirement that the commission hold a hearing concerning these issues and whether or not this hearing could satisfy that.
Okay, good. That's what I
Continue
want.
to have questions. We are happy to participate in that further process.
Okay, good. So that would support an argument for continuation. I guess the other question I had, Mr. Chairman, when we approved the settlement agreement, did we also accept OPC's request that this remain open for potential action up till 2032?
Oh, we didn't need to get there in that vote because there's nothing barring the commission from.
Okay.
Yeah.
Okay, so we haven't, we did rule on that. I just wanted to be sure that that was the case and we have that on the record, that this is an open issue through 2032.
Nothing in the settlement prohibits the commission from tying its hands, although the parties to the agreement tied their hands.
Till 2032.
Correct.
Okay, thank you very much, Mr. Chairman.
Thank you. Seeing nothing else on today's agenda, this hearing is now adjourned.